Breaking: IPOB leader Nnamdi Kanu sues DSS, alleges illegal extraction of his blood samples. IPOB leader Nnamdi Kanu sues DSS, alleges illegal extraction of his blood samples. To my dear listeners from wherever you're listening from, I greet you and stay tuned as I read today's news. Nnamdi Kanu has sued DSS over the alleged illegal extraction of his blood samples. According to a report by Premium Time NG, Nnamdi Kanu urged the court to make an order directing the SSS and the AGF to immediately allow him access to medical facility and material for the practice of his religion. The leader of the proscribed indigenous people of Biafra IPOB, Nnamdi Kanu, has sued the State Security Service (SSS) over allegations of gross violation of his fundamental human rights. Mr. Kanu is being held by the SSS at its headquarters in Abuja after the Nigerian government repatriated him from Kenya in June this year, an action his lawyer termed abduction. He is standing trial on charges bordering on treasonable felony and terrorism before a federal court in Abuja. Maxwell Okpara, one of Mr. Kanu's lawyers, told journalists on Monday that a medical doctor engaged by the SSS has extracted Nnamdi Kanu's blood samples over 21 times. In the new suit, Mr. Okpara said, despite a subsisting order by the trial judge, Bintal Nyako, compelling the spy agency to allow Mr. Kanu change his clothes and practice his Jewish faith, the SSS flagrantly ignored the orders. The Director General of the SSS, Yusuf Bichi, and the Attorney General of the Federation, Abubakar Malami, were listed as respondents in the suit marked FHC ABJ CS 1585-2021. Mr. Okpara, while briefing reporters on Monday, recounted his last visit to the SSS detention facility, where his client reportedly complained bitterly about the doctor extracting his blood, one is suspected to be a quack. Nnamdi Kanu said his demand for the security agency to grant him access to his medical record was repeatedly refused. Mr. Okpara said, in an affidavit of urgency deposed to by Mr. Kanu's younger brother, Emmanuel, the SSS is said to have subjected the IPOB leader to solitary confinement, which is a form of mental and physical torture. This action, he said, subjects the applicant, Mr. Kanu, to inhumane and degrading treatment and in turn constitutes a violation of Section 34, a Constitution of the Federal Republic of Nigeria. The respondents, SSS and AGF, have deprived the applicant access to facility and material to practice his faith and ultimately prevented the applicant from praying and or practicing his faith, and the aforesaid constitutes a breach of the applicant's right to practice his religion. The applicant is a Nigerian citizen who is entitled to the enjoyment of the fundamental right enshrined in Chapter 4 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and Article 5 and 8 of the African Charter on Human and People's Rights, Ratification and Enforcement, Act Cap A9 Volume 1 LFN. The respondents have deprived the applicant access to facility and material to practice his faith and ultimately prevented the applicant from praying and or practicing his faith, and the aforesaid constitutes a breach of the applicant's right to practice his religion. The respondent prevented the applicant from having access to a medical practitioner and legal practitioner of his choice. The respondent subjected the applicant to solitary confinement, which is a form of mental and physical torture, and as such subject the applicant to inhumane and degrading treatment and in turn constitutes a violation of Section 34, Constitution of the Federal Republic of Nigeria, 1999 as amended, and Article 5 of the African Charter on Human and People's Rights, Act Cap A9, Volume 1 LFN. The applicant's right not to be subjected to inhumane and degrading treatment and torture humiliation is enshrined in Section 34, Constitution of the Federal Republic of Nigeria 1999, as amended, and Article 5 of the African Charter on Human and People's Rights, relying on Order 2, Rule 1 of the Fundamental Rights Enforcement Procedure, Rules 209, Mr. Kanu Jr. said, the law empowers any person who alleges that any of the fundamental rights to which he is entitled to has been, or is likely to be infringed upon to apply to the court for a redress. The respondents have no justification to have subjected the applicant to indignity, humiliation, mental torture, and inhumane and degrading treatment. Mr. Kanu urged the court to order the SSS and the AGF to immediately allow him to access to medical facility and material for the practice of his religion. His other prayers read, an order of this court directing the respondent to immediately allow the applicant to appoint him an independent medical practitioner of his choice from a satisfied government hospital to review the applicant's medical files. An order directing the respondent to allow the applicant access to a medical practitioner of his choice and a legal practitioner of his choice. The IPOB leader prayed for an order of perpetual injunction restraining respondents, their authorized agents by whatever name so-called, from further disturbing or interfering with the right of the applicant to dignity of human person and freedom thought, conscience and religion, or in any way infringing on the constitutional rights of the applicant as guaranteed by law, or from making any attempt capable of violating the applicant's rights as guaranteed under the Constitution. At the last sitting in Mr. Kanu's trial on December 2, the trial judge, Mrs. Unyako, adjusted the hearing date in the suit to January 19, 2022, after his defense team staged a walkout on the judge on November 10. Ifeanyi Ejiofor, who led other defense lawyers on the walkout on the judge in the previous proceedings, had applied for an abridgment of time in the trial for an urgent hearing of his pending applications. One of such applications challenges the competence of the charges instituted against his client, but the prosecuting lawyer, Shuaibu Labiran, opposed the request for abridgment of time, informing the judge he had filed a counter application. After listening to arguments by the two opposing lawyers, the judge said the court diary was already congested due to our busy schedule and adjourned the suit till January 19, bringing the date forward by 1 day. To my dear listeners, now we've come to the end of our today's news. Please let's move to the comment section and let's know what your view is all about today's news. Thank you.